From a regulatory perspective, there are broadly three types of private law practice. There's sole practitioner, there is partnership, and there is incorporated legal practice, be it public or private. But beyond that, there is a multitude of ways that law firms actually work together to deliver services for clients or to organise themselves. At one end of the spectrum, there is very simple referral type networks that may be formal or informal, and most law firms will have something to that effect in place, where they're exchanging essentially client inquiries, particularly around matter types they don't practice. So that's at sort of one end of the spectrum, and then we have, you see in the legal marketplace, knowledge networks where firms are connecting for the purpose of exchanging information and perhaps running private CPD. You then see chambers practices, which is really firms, as a network coming together to share premises and facilities. And then you start to come down the spectrum and you see more integrated networks of firms that, for instance, might go to market under a common brand. And there's many examples of this in Australia, historically as well as today, from networks of state-based partnerships which go to market as a national brand, to examples of the global networks and the Swiss veer-in models, which some of the big firms have, and indeed PwC from the speaker earlier today, the Australian partnership as part of the global network of partnerships at PwC. And our organisation, Stacks Law Firm, fits into this category, and I'll talk to that in a moment. And then at the very other end of the spectrum is where you have networks of firms that have that full financial integration, which for all intents and purposes are one firm, but for reasons potentially, perhaps regulatory reasons, are actually structured as with independent firms working together.